Good day. I'm Chilton Varner, the president of the Supreme Court Historical Society. It's my honor to welcome you to today's program, a virtual lecture delivered by Professor David Schwartz, a chaired professor in the law school at the University of Wisconsin. The Society continues to pivot and perform, even though the pandemic seems stubbornly not willing to give completely up. We're hopeful that, at least by the fall, we'll be able to return to in-person programming. Having said that, the virtual lectures that we have presented during the pandemic have proven to be quite popular. They have reached members of our society who had never been to Washington to hear a live lecture. So regardless of when the Supreme Court building reopens, we suspect that we will continue to have some virtual addendum to the programming so that we can continue to increase our audience. Today's program will feature, as I said, a lecture by David Schwartz, professor of law at the University of Wisconsin. He bases his remarks today on his book published in 2019 entitled The Spirit of the Constitution, John Marshall and the 200-Year Odyssey of McCulloch v. Maryland. You can see by the publication date that his book remains quite timely. Professor Schwartz will talk for about 30 minutes. He will then stop his prepared remarks in order to take questions or comments from our virtual audience. If you have such comments or questions, you may convey them to us by use of the Q&A feature in your Zoom connection. The executive director of the Society, Jim Duff, will be screening those submissions from the virtual audience, and he will manage to pose as many of the questions as is possible given our time constraints. Now, a little bit about our speaker today. Professor Schwartz teaches and writes in 3 fields: constitutional law, evidence, and civil procedure. I call that the bedrock. He has also authored 2 case books, one on constitutional law, the other on evidence. As I mentioned earlier, his book on John Marshall and McCulloch versus Maryland, it remains quite popular and was published in 2019. Now, Professor Schwartz is not just a fine writer and researcher. He is a 2-time recipient of the Classroom Teacher of the Year Award in 2004 for the first time and 2013 more recently. Professor Schwartz joined the University of Wisconsin law faculty in fall 1999 after 12 years of law practice specializing in employment law and civil rights litigation. Unlike many law professors, he is deeply steeped in the practice of law, and we believe that will make his remarks today even more interesting. After graduating from law school, Professor Schwartz clerked for the Honorable Betty B. Fletcher of the U.S. Court of Appeals for the Ninth Circuit. I'm delighted to welcome Professor Schwartz to the Society's virtual platform. I think you have a fine treat to look forward to. Professor, the virtual podium now belongs to you. Welcome.
So much. And I want to thank Chilton Varner, Jim Duff, and Jennifer Lowe for this invitation. I'm honored, and it's a great pleasure to be in front of the Supreme Court Historical Society. I can't think of a better audience, frankly, for this presentation. So I'm delighted to be here. Every American lawyer knows McCulloch versus Maryland. We all know that landmark case because we studied it in the opening weeks of our con law class. We remember, at least if we hung on to our course outlines, that John Marshall's 1819 unanimous opinion upheld Congress's implied power to create the Second Bank of the United States, thereby establishing the authoritative interpretation of the necessary and proper clause. Since the publication of the first constitutional law casebook in 1894, McCulloch has been presented as the leading case on the powers of Congress in every constitutional law casebook. McCulloch is widely considered to be the single greatest judicial performance, as Felix Frankfurter put it, by the single greatest Supreme Court justice. Constitutional scholars have called McCulloch the most far-reaching decision ever handed down by the Supreme Court and the most canonical of cases in American constitutional law. And that is to say, the case that's most essential and most important for members of the legal profession to read and to know. We know McCulloch to be the authoritative doctrine on implied powers of the federal government. McCulloch is one of the most frequently cited constitutional law cases of all time, rivaling Brown versus Board of Education, cited more frequently in US Supreme Court decisions than Marbury versus Madison. In the 2012 case, NFIB versus Sebelius, the case that challenged the constitutionality of Obamacare, the Affordable Care Act, the parties and the justices' opinions discussed McCulloch at some length, and they were closely divided about whether Marshall's decision meant that the law, the ACA, was constitutional or not. So McCulloch is apparently as authoritative today as it was 200 years ago. Presumably, that means that McCulloch settled the question of Congress's implied powers and the meaning of the necessary and proper clause once and for all from 1819 to the present day. That's how great canonical cases work, right? Well, no, not this one. In fact, McCulloch's 200-year journey to its present-day canonical status followed a much more tortuous path. In its first 70 years, McCulloch did not appear destined to become a canonical case. The scope and the extent of the powers of Congress were debated frequently in those tumultuous decades, including the Civil War, as were questions about the nature of the Union and the supremacy of federal law, all of these things covered in McCulloch. Yet from 1819 to 1892, the Supreme Court rarely invoked McCulloch as a foundational statement of those principles. The case that we now regard as the greatest constitutional law decision was for many decades viewed primarily as a decision about intergovernmental tax immunity and currency regulation. So let's start the story of McCulloch versus Maryland, and we have to go back to December 14th, 1790, when Treasury Secretary Alexander Hamilton issued his report on a national bank. Hamilton argued that a national bank would provide a reliable source of loans to the government, and it would facilitate revenue collection. What's more, the bank would generate commerce by increasing the volume and speed of commercial transactions by enabling parties to use reliable paper money and bank deposit credits in place of hand-to-hand exchange of gold and silver coins, known as specie. The bill to charter the first bank, however, was vigorously opposed by the nascent Jeffersonian opposition, led by Virginia Congressman James Madison. When the opponents' policy arguments failed, they turned to constitutional arguments. The bank exceeded the powers of Congress, they said. No enumerated power authorized the creation of a bank, and implied powers were to be strictly limited to those absolutely necessary to exercising the enumerated powers. But over those objections, the bill passed Congress, and President Washington signed it after Hamilton successfully refuted the arguments of his two cabinet adversaries, Secretary of State Thomas Jefferson and Attorney General Edmund Randolph. Jefferson had argued that implied powers could extend only, quote, to those means without which the grant of power would be nugatory. Otherwise, Congress would take possession of a boundless field of power, no longer susceptible of any definition, end quote. In his written response, Hamilton argued that the opponent's narrow interpretation of the federal government's powers, quote, would be fatal to the just and indispensable authority of the United States. The Constitution's grant of powers, Hamilton argued, especially those which concern the general administration of the affairs of a country, its finances, trade, defense, etc., ought to be construed liberally in advancement of the public good. He further argued that the bank's charter and its banking activities were, quote, to be regarded as a regulation of trade. Banks and corporations, he said, are a means implicitly residing in the sovereignty of all governments. Therefore, little less than a prohibitory clause can destroy the strong presumptions supporting the power to create a bank. This convinced Washington, and he signed the bank bill into law on February 25th, 1791. The bank had a 20-year charter, and when it expired in 1811, the number of state banks during this time had grown from 4 in 1791 to 90 in 1811. Many of those state banks had a competitive and adversarial relationship with the national bank, and their opposition was enough to kill the bill to recharter the first bank by one vote in both the House and the Senate. But the result of this non-renewal of the Bank of the United States turned into something of a financial disaster in public finance, because the chaotic system of state banknote circulation produced a disuniform, balkanized currency situation that created massive problems for the federal government's finances during the War of 1812. That experience during Madison's presidency converted Madison, the first bank's erstwhile opponent, into an ardent supporter of a new national bank. It was at his urging that Congress enacted a bill to charter the Second Bank of the United States, which Madison signed into law on April 10, 1816. The Second Bank got off to a shaky start. Overextended by its aggressive lending, it abruptly began calling in many of its loans as the economy entered a downturn in 1818, worsening the nation's first major depression, which became known to historians as the Panic of 1819. The public perception of the bank turned increasingly negative. Now we go to Maryland. In February 1818, Maryland enacted a law, quote, to impose a tax on all banks or branches thereof in the state of Maryland, not chartered by the legislature. That law referred to exactly one bank, the Baltimore branch of the Second Bank of the United States. The tax was designed to undermine the bank's competitive position vis-a-vis state-chartered banks for lending business within Maryland. When the law went into effect in May 1818, McCulloch, the manager of this Baltimore branch, issued notes without paying the tax, and a Maryland Treasury official brought an action for debt against him as the bank's manager or cashier to collect $2,500 in penalties. The two sides cooperated. They wanted the case resolved by the Supreme Court, and they litigated the case on agreed facts in the Maryland courts, which upheld the tax. And the plan was to fast track the case to the US Supreme Court. McCulloch versus Maryland was argued before the US Supreme Court beginning on February 22nd, 1819. At that time, the Supreme Court room was in the basement of the Capitol building. Directly overhead was the Senate chamber. And at the very same time that McCulloch versus Maryland was being argued, the Senate was rancorously debating the bill to admit Missouri as a slave state, which led to the year-long debate culminating in the Missouri Compromise. So a lot going on in the Capitol that particular week. The McCulloch argument was also an important event in the Capitol that day, as emphasized by the makeup of the two legal teams. For Maryland, Luther Martin, age 71, was one of the few surviving members of the Constitutional Convention, where he had been a leading advocate for the small states and an anti-federalist ultimately. He had served as Attorney General for Maryland over many years. He defended Aaron Burr at the latter's 1807 treason trial, and he had argued 25 cases before the Supreme Court prior to McCulloch. His colleague, Joseph Hopkinson, had defended Justice Samuel Chase in Chase's 1804 impeachment trial. He co-counseled the Dartmouth College versus Woodward case with Daniel Webster, and he had served as a congressman from Pennsylvania, where he'd later be appointed to a federal judgeship. Walter Jones, who unfortunately I don't have a picture of, was a Supreme Court regular. He argued 169 Supreme Court cases between 1815 and 1835. On the other side, representing the bank, was Daniel Webster, who was beginning to establish his reputation as godlike Daniel, the nation's foremost orator. and he too was a preeminent advocate before the Supreme Court. His colleague, William Wirt, had been handpicked by Jefferson to prosecute Aaron Burr for treason in 1807, and Wirt later became the longest tenured US Attorney General in history, serving for 12 years, from 1817 to 1829, for 2 different presidents. All of these luminaries, however, were outshone by the third and final member of the bank's team. That was William Pinckney. Although he's not so well remembered now, he at the time was the recognized leader of the Supreme Court bar until he died prematurely in 1822. He had been described by John Marshall as the greatest man he had ever seen in a court of justice. Now, there are no artist's renderings of the McCulloch oral argument. The closest I have is this painting, which hangs in a building in Dartmouth College. And it's a highly inaccurate artistic reimagination of the Dartmouth College versus Woodward oral argument, which took place just a few weeks before McCulloch. Daniel Webster is pictured here giving the argument. The McCulloch argument lasted an unprecedented 9 days, from February 22nd to March 3rd. The opinion in McCulloch was issued 3 days later, March 6th, 1819. Chief Justice Marshall read the case aloud to a packed courtroom audience. Both the length of the oral arguments and the rapidity and speed of the court's decision are instructive. It tells us about how cases went in those days. Lawyers did not submit briefs, written briefs in the Marshall Court era, but they instead delivered their arguments as lengthy speeches. Marshall would sit at his desk taking copious notes of these oral arguments, and he'd rely on these notes heavily in drafting his opinions. For that reason, Marshall's opinions are sprinkled with phrases like, "it has been said," or "it has been truly said," or "it has been argued at the bar." Contemporary readers understood those as signals that Marshall was paraphrasing part of an oral argument. Even when those signals were absent, Marshall did paraphrase a great deal. More than a decade earlier, Marshall had researched, written, and published the first authoritative biography of George Washington. During his research of that work, Marshall had pored over Washington's papers, including the records of the first bank debates. So Marshall knew Hamilton's arguments very well, and he copied from them freely. To John Marshall, speed and substance were far more important than originality. The McCulloch opinion is 10,000 words, and it has 2 main parts, and here's a refresher. Marshall stated the first of 2 questions simply. Has Congress power to incorporate a bank? Because the federal government is acknowledged by all to be one of enumerated powers, he wrote, the principle that it can exercise only the powers granted to it would seem too apparent to be disputed. Nevertheless, he pointed out, the express powers granted to the federal government were written in broad, general language, and they also carried with them implied powers. The bank's validity depended on the implied powers of Congress because the power to incorporate a bank is not expressly granted. Implied powers are the means by which Congress executes the great powers expressly granted in the Constitution. They're necessarily left to implication because a Constitution is necessarily written in broad outlines. Maryland's counsel argued that implied powers have to be limited to those without which an express power would be nullified, would be useless. But Marshall rejected that contention. Congress, he said, has to have discretion to choose among any means convenient or well-adapted or conducive to implementing the granted power. Reading the Constitution in the narrower sense would undermine the Constitution's adaptability to unforeseen crises and its ability to endure over time. Implied powers, Marshall observed, would thus exist under any sensible interpretation of the Constitution, whether or not we had a necessary and proper clause, but their existence is confirmed by the necessary and proper clause. That clause, which comes at the end of the enumeration of powers of Congress in Article 1, Section 8, explicitly authorizes Congress to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, Article 1, Section 8, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. The bank was constitutional, Marshall concluded, because, quote, it is a convenient, a useful, and essential instrument in conducting the national government's fiscal operations. Having determined that the bank was constitutional, Marshall then considered whether Maryland could tax it. The question had to be analyzed against the backdrop of federal supremacy, whose essence is to remove all obstacles to federal government action within its sphere of authority. State taxation was a potential obstacle. Taxation is essentially a power to regulate and even to destroy what is taxed, limited only by the political wishes of the state's constituents. But the state's sovereign power of taxation extends only to powers that can be conferred by the state's constituents, which did not include a power over the national government. Therefore, states could not tax operations of the national government, just as a part cannot control the whole. So that's the general straight up understanding of McCulloch versus Maryland. We think we know McCulloch well, but the opinion is actually filled with ambiguity, subtlety, misdirection, at times even confusion. The McCulloch opinion bears multiple rereadings and rewards close study. I have a vested interest in staying that since I wrote the book on it. It's important not to let our minds glaze over between the familiar phrases while we skip from one to another, the phrases that are so familiar from the opinion that they're now almost cliches. Let the end be legitimate. This government is acknowledged by all to be one of enumerated powers. A constitution intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. And of course, the all-time favorite, we must never forget that it is a constitution we are expounding. It's not just the superficial familiarity of the opinion that prevents us from reading it clearly. It's also 200 years of constitutional history and constitutional ideology that we are ourselves immersed in that can keep us from seeing important principles and claims made by Marshall that are hiding in plain sight. This brings me at last to the suggestion in my title that McCulloch was overruled, at least in part, and for a long time, for many decades. But to see this, we have to explore the seemingly familiar aspects of Marshall's opinion more deeply and then trace them forward in time from 1819. Now, present-day Supreme Court cases will tell us that the federal government and the states are dual sovereigns, whose laws are paramount in their respective or separate spheres. Remember that phrase, separate spheres. This is supposedly how the framers, in Justice Kennedy's phrase, split the atom of sovereignty. But what did Marshall have to say about this? Marshall didn't speak of atoms, split atoms, of course, but he did speak of sovereignty, and he did use the word sphere, though not spheres in the plural. Here's some key language. If any one proposition could command the universal assent of mankind, we might expect it would be this, that the government of the Union, though limited in its powers, is supreme within its sphere of action. This would seem to result necessarily from its nature. It is the government of all, its powers are delegated by all, it represents all, and it acts for all. Well, what about the state sphere? Are the states supreme within their own sphere of action, as our modern federalism doctrine seems to say? Marshall never says that. While he pays lip service to state sovereignty, calling Maryland a sovereign state in the very first line of the opinion, he never says that the states even have a sovereign and untouchable sphere of action. And he implicitly denies that they do. Here's the next key passage. No principle not declared can be admissible which would defeat the legitimate operations of a supreme government. It is of the very essence of supremacy to remove all obstacles to its action within its own sphere, and so to modify every power vested in subordinate governments, as to exempt its own operations from their own influence. This effect need not be stated in terms. It is so involved in the declaration of supremacy, so necessarily implied in it, that the expression of it could not make it more certain. So even though the Constitution doesn't expressly say so, the states are subordinate governments, according to Marshall. They have no separate sphere. They have no separate sphere because their every power is subject to modification by supreme law within the federal sphere. Such is the difficulty of shedding the constitutional rhetoric of separate spheres, plural, that when I discussed this passage in Marshall's use of the term sphere in my book, I simply assumed that he accorded spheres to the states as well. It's an error in the book, which I regret, because as I say, successive readings of this case, I continue to learn new things every time I read it. Consider the actual result of McCulloch. An enumerated power to create a bank is part of the supreme law of the land, and it modifies potentially every power vested in the subordinate, that is, state governments. In McCulloch itself, the exercise of the implied federal power blocked the states from exercising the most sovereign of all sovereign powers, the power of taxation. So implicit in McCulloch are two key points about implied powers. First, implied powers do not have second-class status relative to enumerated powers. They're as much the supreme law of the land as are the enumerated powers. Second, what is it that makes something an implied power? It's that it is not part of the definition of the enumerated power. As Marshall says, among the enumerated powers, we do not find that of establishing a bank or creating a corporation. As long as the implied power is necessary and proper, which Marshall defines as conducive or convenient, rather than strictly necessary, to exercising an enumerated power of the federal government, it is legitimate and it is supreme, potentially modifying any state power that may interfere with it. And that's why states have no sphere of their own. We can't know in advance what the subject matter of implied powers will be. In McCulloch, the power was the power over banking, yet nothing in the Constitution enumerates a federal banking power. Yet consider this statement from the Supreme Court in the 1936 decision in Carter versus Carter Cole. In exercising the authority conferred by this clause of the Constitution, that is the Commerce Clause, Congress is powerless to regulate anything which is not commerce. But if McCulloch was controlling law, how could that statement be true? Implied powers are precisely things that are not enumerated. If regulating coal mining wages and hours was conducive to regulating interstate commerce and coal, the issue in Carter Cole, even under the narrowest definition of commerce, the buying and selling of things across state lines, why shouldn't Congress have had the power to regulate coal mining wages and hours? This erroneous view of McCulloch, which characterized the Lochner era, and this erroneous view of implied commerce powers, did not arise out of whole cloth in 1936. It dates back to 1824. Southerners and their pro-slavery allies vehemently objected to McCulloch in general and to the idea of applying McCulloch's implied powers principle to the Commerce Clause, and it's not hard to see why. Consider what would happen doctrinally if Congress had an implied power to do anything conducive to commerce regulation. Consider all the ways that abolition of slavery could be conducive to a regulation of interstate or foreign trade. Congress could reasonably decide that the best way to effectuate its ineffectual efforts to abolish the international slave trade, there was a lot of smuggling and violation of the law, would be to eliminate slavery at its source. Congress could reasonably decide that competition between slave and free agricultural production was unfair and choose to regulate it, or by abolishing slavery. Or Congress could simply decide that interstate and foreign trade should not be tainted by slave-produced goods. Pro-slavery constitutionalists were well aware of all this. In an 1824 House debate, John Randolph, congressman from Virginia, warned his colleagues that if an implied commerce power to build roads and canals were recognized, then the same principle of implied commerce powers would authorize Congress to, quote, emancipate every slave in the United States. John Marshall, who lived most of the year in Richmond among his strict constructionist opponents, and who owned close to 200 slaves during his lifetime and never emancipated a single one, was aware of this too. In 1824, he wrote the opinion in Gibbons versus Ogden, holding that the commerce power extended to steamboat transportation. Even though he had previously held, in a case while riding circuit on the lower court, that Congress's power to regulate navigation was an implied power pursuant to its power to regulate trade under the Commerce Clause, in Gibbons, he dispensed with any implied power analysis. Instead, he held that navigation fell within the definition of commerce, and he didn't discuss or even cite McCulloch. Gibbons versus Ogden set a doctrinal path that persists to the present day, in which the court asks whether a law falls within a definition of commerce. Today, it's one expanded to include the substantial effects test, rather than asking whether the law is conducive to regulating commerce, as McCulloch would frame the question. John Marshall died in 1835, never again citing McCulloch for its principles of implied powers. His successor was Roger Taney, who assumed the Chief Justiceship in 1836. Taney hated everything about McCulloch's federalism principles, but the Taney court did not believe in overruling prior decisions. And indeed, it didn't overrule any Marshall court cases, even though it disagreed with several of those Marshall court decisions. The Taney court's approach to McCulloch was to ignore it, never citing it for implied powers or any federalism principles, and to subtly undermine it. In early 1837, Taney's first full term as Chief Justice, the court decided New York versus Milne, involving a challenge to a New York law that required the master or owner of any ship landing in New York Harbor to submit a written report providing the name, birthplace, residence, age, and occupation of all foreign or interstate passengers, and to post a bond for the cost of maintenance or removal of impoverished immigrants. The law plainly regulated navigation, which was commerce under Gibbons. And indeed, Congress had already imposed similar regulations on arriving immigrants. But the Supreme Court, over the lone dissent of Justice Joseph Story, upheld the law on the ground that it was not a regulation of commerce, but a, quote, police regulation designed to aid the state's ability to guard against the moral pestilence of paupers, vagabonds, and possibly convicts by controlling immigration. The opinion was written by Justice Barber from Virginia, a states' rights firebrand, and he made his Milne opinion into a states' rights manifesto. Barber asserted that when a state acts within, quote, the legitimate scope of its power as to the end to be attained, it may use whatsoever means, being appropriate to that end, it may think fit. And when it came to, quote, all those powers which relate merely to municipal legislation, or what may perhaps more be called internal police. And by the way, everyone knew at that time that slavery counted as municipal or internal police legislation. The authority of a state is complete, unqualified, and exclusive. The key word is exclusive. This language in Milne represents a reversal of McCulloch in two respects. First, it suggests that states' reserved powers can defeat at least some plausible claims of implied powers under McCulloch. Recall that an implied power is one that is not expressly granted to Congress, and thus it's presumptively reserved to the states, except to the extent that it is conducive to executing an enumerated power. But Barber said that state police powers are exclusive, suggesting that reserved state powers might defeat a claim of federal implied powers. Even more moderate Taney Court justices agreed with this proposition. Second, Milne argued that state police powers carry implied powers that may extend into the federal sphere, such as the federal commerce power. The New York passenger report law was not in itself a regulation of foreign paupers entering the state, but a regulation of navigation used as means to that end. So long as the end was legitimate within state police powers, state could use legislative means that were indistinguishable from federal commerce regulation. This is truly McCulloch in reverse. A broad Taney Court consensus held that the concept of reserved state powers has its foundation in the sacred law of self-defense, which no power granted to Congress can restrain or annul. This notion that conflicts between federal and state law might be resolved in favor of the states contrary to McCulloch and even to Gibbons for that matter, commanded a consensus on the Tawney Court. How this idea would be harmonized with the Supremacy Clause, the Tawney Court never worked out. But the anti-McCulloch essence of cases like Milne built up a robust concept of reserve state powers that neutralized implied federal powers, and that conception would dominate constitutional jurisprudence for the next century. We can draw a straight line between the Tawney Court's conception of reserve state powers as a sacred right of self-defense that could defeat implied federal powers, and the doctrine underlying the Lochner-era Commerce Clause cases, such as United States versus E.C. Knight, Hammer versus Dagenhart, and Carter versus Carter-Cole. The motivation behind the Lochner-era cases was different from that of the Tawney Court, but the theory was largely the same. Certain subject matters of regulation, formerly slavery, but now labor, agriculture, manufacture, the production of goods generally, were reserved to the states under the 10th Amendment and could not be reached by implied powers. The 10th Amendment, under this view of the Lochner-era court, limited the scope of McCulloch. So in conclusion, we can see that McCulloch fell out of favor and was essentially overruled by the Tawney Court. Even after the abolition of slavery and the expansion of the federal sphere from the Reconstruction Amendments and the post-Civil War rejection of strong form states' rights theory, McCulloch remained largely at the margins. From the end of the Tawney Court until the early 1890s, McCulloch was viewed as an implied powers case only insofar as it extended to currency and banking. How then did McCulloch become the canonical case it is today? For that, I'm going to refer you to my book, which tells the story in detail. During the Lochner era, McCulloch was cited in both majority and dissenting opinions, and it was cited as often to strike down an act of Congress as to uphold one, which brings us full circle to the 2012 NFIB case, in which both sides invoked the authority of McCulloch. But perhaps this shouldn't surprise us at all. McCulloch is filled with ambiguities, and it lends itself to conflicting interpretations in several important ways. And maybe that is an essential element for any canonical text. Thank you, and I look forward to your questions.
There we go. Thank you very much, Professor Schwartz. It was a very stimulating presentation, and we're now, as you say, going to be taking questions from the audience. If you have questions, please type them into the Q&A section, and we'll get to as many as possible. I'll start with one. Did you think, you referred to the ambiguities in the McCulloch decision, and do you think that some of those ambiguities may have had anything to do with the fact that it was published 3 days after oral argument? Is there any suggestion that in subsequent cases or had the court taken more time to write an opinion, as you know, is the current practice, if some of those ambiguities might have been clarified?
Well, it's certainly possible that ambiguity, one source of ambiguity is haste and things that could have been ironed out and said more clearly. But another way to look at it, and one that's consistent, I think, with how Marshall is viewed as a kind of master tactician of the judicial craft, who is navigating a very difficult political environment, is that his ambiguities are strategic. We have to remember that Marshall was a Federalist and a nationalist, but he is writing in 1819 in the 19th year of the ascendancy of essentially a one-party rule of the Jeffersonian Republicans. Most of his colleagues are appointed by Jefferson and Madison by this time. So he has a lot of pressure, I think, to tamp down whatever nationalist instincts he might have. And I think that would lead to a lot of strategic ambiguity. Now, I mentioned how Southern slave owners would have been particularly resistant to the idea of implied commerce powers. And what's fascinating to me about McCulloch is that despite a long history, starting with Hamilton, of arguments that the bank is a generator and facilitator of commerce, and thus could easily be upheld as necessary and proper under the Commerce Clause, Marshall didn't do that. He ultimately says he doesn't actually cite any particular enumerated power to which this implied power is attached. He says it's conducive to the government's fiscal operations and to its management of finances. He doesn't say it's conducive to the regulation of commerce. And I think that's one of those ambiguities. You know, which enumerated power is it that I think was strategic?
Are there other questions? Hold on just a sec. I'm sorting through them. Okay. Were there other cases that show Justice Marshall not deferring to the 10th Amendment? And is there a pattern?
Yes. And by not deferring to the 10th Amendment, you know, so he certainly did not read the 10th Amendment in the way that the Taney Court and the Lochner Court did, as a kind of placeholder for a set of very specific subject matter areas that Congress could not regulate, even if that regulation would be conducive to exercising an enumerated power. So he didn't see it that way. He also, in McCulloch, says that you know, the 10th Amendment took the word, you know, the word expressly was taken out. In the Articles of Confederation, Congress was limited to those powers expressly delegated. That word expressly does not appear in the Article 1 vesting clause of the Constitution. There had been a proposal in the 10th Amendment to say the powers not expressly delegated to the national government are reserved to the states. Expressly was voted out of that amendment. And so Marshall's aware of that. He refers to it in McCulloch. You know, he has other nationalist cases that I think, you know, could be read as not deferring to the 10th Amendment. And it's the ones that, you know, the kind of the Marshall Court classics. It would be Cohen's versus Virginia. And even I would say the case of Worcester versus Georgia. Mm-hmm. All of those cases are being non-deferential to state, to the idea of state reserve powers.
I think it was McCulloch was a unanimous. One of the questions was that they think was a unanimous decision. Is there any reason to believe that Marshall's fellow justices were not really on board with him? That's
a great question. And, you know, so one of the things we know, because of the, you know, the fact that they're you know, the technology of the day is a quill pen. And, you know, he has to get his draft to the printer and it's being released within 3 days. The Supreme Court did not have the practice in the Marshall Court that we have today of circulating draft opinions. And so there is going to be, you know, some kind of delegation of discretion given to the opinion writer. And, you know, what they do is they have a conference. You know, Marshall had, he basically, you know, persuaded all of his colleagues to room at the same boarding house. The Supreme Court met for only about 6 weeks in Washington, which was still kind of a swamp and an undesirable place to live. And they wanted to keep their time there as short as possible. So they lived in the same boarding house and they would talk about the cases over meals. And so clearly, you know, Marshall had a sense of what his colleagues were willing to say. But when it comes to the finer points, he's going to be largely on his own. And so, you know, we don't have a historical record of, you know, whether anybody, any of his colleagues felt surprised or betrayed in some way by something Marshall put in there that they disagreed with. There were occasional dissenting opinions, despite Marshall's effort at achieving unanimity in every constitutional case. And I'm only aware of one instance and it was actually in the Milne opinion, so it wasn't even a Marshall Court opinion, where we have a record of some justices saying, you know what, this author changed things from what we agreed on. So we don't have any kind of historical evidence that that happened in the Marshall Court. What we have is, the occasional dissenting opinion.
Another question we received, your lecture focuses on the McCulloch as case as it bears on the power relationship between the federal government and the states. The necessary and proper clause also extends to all constitutional powers, including the executive and the judiciary. Do you have any thoughts or comments on how McCulloch bears on separation of powers? Could, for example, Congress require the president in exercising the pardon power require some sort of record or written foundation for a pardon grant, demonstrating its consistency with the purposes and objectives of the pardon power?
That's a great question too. I don't read McCulloch as bearing on that question, but I do read the necessary and proper clause as potentially bearing on that question. And the way the necessary, as the questioner suggests, the wording of the necessary and proper clause seems to authorize Congress to legislate on any power, whether it's Article 1, Section 8, or powers that are assigned to other branches of government, such as the judiciary or the president. And so, that leaves a fairly wide-ranging argument, separation of powers argument, that Congress, that Congress has legislative powers to advance the negotiation of treaties, for example. I don't know that I'm not aware of cases where that has been specifically argued, and I don't read McCulloch as directly relating to that. But it does bring to mind, not in the separation of powers context, another ambiguity, and this circles back to the first question. What are the powers delegated to the United States? That's kind of a mysterious phrase. One could say, well, the United States is referred to specifically as having a power under the guarantee clause. But there is also an argument that there are inherent powers that are not enumerated. Alexander Hamilton argued every government has the power to charter corporations and create banks. And that's, even if it's not enumerated, it's an inherent power. And so one interpretation of McCulloch and the necessary and proper clause is that the necessary and proper clause is acknowledging the existence of inherent powers like that all governments have. And that Marshall is kind of putting his seal of approval on it when he doesn't specifically name an enumerated power. We could read McCulloch to say, because Marshall is vague about any specific enumerated power and just says the finances of the government, what he's really saying is, look, all governments can manage their own finances. And so, so really what we have, the bank is necessary and proper to an inherent, another unenumerated power, the power to manage national finances.
David, we have so many questions here. I'm afraid we're not going to have time to get to all of them, but I'm going to go through a couple more at least. And it's been a very stimulating lecture. Do you think that McCulloch set the stage for the modern Supreme Court, and that it prefers clean cases to be argued from the lower federal courts and state high courts like Maryland's Court of Appeals? Perhaps contrast this with the messier facts of Marbury v. Madison.
I don't read McCulloch as a precedent for how Supreme Court cases are litigated. I think we have, every now and then we learn that a case is a test case and all the parties want the Supreme Court to decide it, as happened in McCulloch. And but that seems to be more the exception, and the general rule is more that it is a truly adversarial case. The parties, maybe one, maybe not both parties want the Supreme Court to decide it. So I would say McCulloch is not, sort of a precedent of for how cases get litigated to the Supreme Court.
What inspired you to begin working on McCulloch?
I was interested in the idea of a landmark case, and the idea that, here's this case, and it, the claims that were being made about it struck me as historically excessive. There were historical scholars and constitutional historians who said McCulloch laid the foundation for the New Deal. It laid the foundation for the modern welfare state. It established this law. And I was interested to explore, well, what's the causal connection between this 1819 decision and these things that happened in the 20th century? And the more I looked into it, the more the mystery deepened, because to my surprise, I found that McCulloch kind of disappeared from view, that it just wasn't being cited by the Supreme Court. I also began with a skepticism that Supreme Court decisions really could be nation building decisions, as opposed to what I call in the book defensive nationalism decisions. The Supreme Court can strike down laws. They can set up principles, to say that, these restrictive arguments or strict construction arguments, they can reject strict construction arguments, but they can't induce Congress to build infrastructure. That was a big issue in the early 19th century. They can't induce Congress to pass legislation. And I think it's, legislation, affirmative legislation builds the nation, whereas Supreme Court decisions just kind of, have an important but less affirmative role.
Mm-hmm.
So it was the skepticism that kind of got me interested.
What comes next for you?
I'm still interested in constitutional history. I have some ideas about James Madison's, a revisionist take on James Madison's role in, his reputation, questioning his reputation as father of the Constitution. It's one project that I'm working on. And another is a kind of a constitutional history of federalism.
Great. Well, we look forward to your next work. And I want to thank you very much on behalf of the Society and our members and participants today for your stimulating and informative talk. And I want to remind our audience members that signed copies of Professor Schwartz's book are The Spirit of the Constitution, John Marshall, and the 200-Year Odyssey of McCulloch versus Maryland are still available on our Society's gift shop. You can find it at www.supremecourtgifts.org. It's a great read. I'm going to hold up a copy and without any hesitation, recommend it to you. Thank you all for joining us today. And because this is a relatively new format, and as our president, Chilton Varner, mentioned at the outset, it's a relatively new experience for the Society and our members. We're sending out a survey later this afternoon to everyone who registered in advance. And we hope you do respond to it. We want to make these programs as rich and accessible to as many people as possible. For more information about the Society and our future events, please visit our website at www.supremecourthistory.org. This is going to be our last program until September. And we'll come back in the fall, and we look forward to all of you joining us for our next program. And we look forward to another good book by Professor Schwartz, so we can invite him back. Thank you all very much for joining us today, and we are adjourned.